Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today, I'm doing a recap of something I covered on a previous live stream. However, I don't just clip out my performance and clip that out and post that to YouTube. I don't really like to do that. I'm actually recapping, reprising, and adding to the contract review that I did on the live stream earlier this week. Or was it last week? I don't even remember. Doesn't matter, because who knows when you're watching this video. Okay, so this is a guest contract at a convention. I am not able to disclose what convention this is from. You can draw your own conclusions about what convention it may be from. The provisions in it are similar to a contract that was disclosed to Anime News Network, but I have not been given permission to disclose what convention this contract is from. So that being said, I have some information to kind of go through. I'm not going to read through the entire contract. If you want that, you need to go ahead and check out that live stream. Or you can just pause the video and kind of read as we go here if you want. I'm going to scroll through it, so you will be able to see all of it, but I'm not going to read it. I've got some highlighted sections that actually kind of matter. We're going to hit those really quick, and then we're going to talk about what they mean. And finally, we're going to talk about what should maybe be added to this contract based on what we know about what has happened at KamehaCon and with other conventions around, where suddenly we've got guests canceling and guests being canceled and all of that stuff. How do guests and how do contract holders, how do they protect themselves from this sort of weird possibility? A brief note about this contract. This contract is only about 3.5 pages long. Some people think that you have to have a super voluminous contract for it to be valid, or for it to matter, or for it to even be good. You don't. Actually, up until now, this contract was probably just fine, because there wasn't really a consideration that a convention would be canceling a guest at the last minute, or that guests would be canceling on the convention at the last minute. There's a bunch of benefit to entering into this type of contract for both parties. The convention gets a voice actor that has some level of notoriety, and the idea would be that they would attract guests. Conventions like to maybe diversify the pool of talent to appeal to a broad spectrum of people across a fandom, and then that way they get to bring in more and more customers to see their voice actor of choice. And of course, then that has residual benefits to all of their other contract attendees, like vendors and artists and stuff like that, as their art and products are consumed at a higher rate by a higher volume of people. On the voice actor side, they are encouraged to fulfill their contract because they stand to make a large amount of money, and they get to engage directly with their fan base. These are massive boosts to their career in various ways. One, people get to meet the person behind the character. Of course, that carries with it a specific amount of value, because you don't get to see them until you go meet them, or you watch videos online or something. But as you get to interact with them, it will color your perspective on who this person is going forward. With that said, the other obvious motivator is money. They make a lot of money at these conventions if they're a prominent voice actor. Not very prominent voice actors will still do okay, because people will come to see them. They will pay for autographs and stuff like that. High-powered voice actors, or highly prominent voice actors in a particular series or theme or fandom that's being focused on by the convention, they stand to make really an astonishing amount of money. $30,000, $40,000, $50,000, sometimes more, depending on who you've got. They make a lot of this money in cash from the fees for their autographs and a brief interaction with them. So with that said, let's start going through this contract and look at how that plays out and what's kind of important in here. You've got some general information listed right up here. Then the other thing that we don't have, and this is going to be specific to various guests, is a provision of attached appendices. Okay. One thing that's mentioned later on in this contract, and I'll point it out when we get there, is that some of these contracts are going to have a minimum guarantee. That means that the voice actor or other person who's contracting is guaranteed a minimum amount of money from their time at the convention. So let's say it's $1,000. It means everybody who comes up and gives them $10 for an autograph chips $10 away from that $1,000 amount. If they get over $1,000, the convention pays nothing to the artist. They have made up their minimum guarantee, and anything that they take on top of that is theirs according to the terms of the contract. If they make less than $1,000, say they only make $800 for whatever reason, low attendance, less than predicted popularity, all sorts of reasons could cause them to make less. But let's say they make $800. Well, then the convention owes them $200. Those appendices are going to be specific for each individual person. And there could be different appendices as well. If you think about KamehaCon, Chris Sabat, for example, is doing an extended tour of Otakutron 5000 Studios, or whatever it's called. Okratron? I don't even know. But the studio where they do a lot of the Dragon Ball voice dubbing in the United States is there's going to be a guided tour of that studio. The convention tickets to get that guided tour are limited. They cost quite a bit of money, I think $550. And it's highly likely that Chris Sabat, as it being his studio and him leading the tour, would get an extended, would get some sort of cut out of that ticket sale. That would be covered in one of these appendices. Unfortunately, this is a form contract from a particular convention, and there isn't any specific appendice that is attached to it, because I don't even know what special events take place at this particular convention. It's not really relevant to this discussion. Okay, but just know that's the appendices they're talking about, and anything that's attached to this agreement contemporaneous with the signing and incorporated into the signing, which the appendices would have some sort of language that says, this appendix is incorporated herein to the agreement dated such and such, signed by so-and-so and the event venue. Okay, they would have some sort of incorporating language. They would actually keep them together, and that would be how you would identify them. They would both be signed, likely, and probably both be signed on the same date or a short time thereafter. But they would specifically reference the original document so that you know it's actually incorporated into it. Okay, that said, we can skip down a couple sections. This is just the event date and venue. It is understood, 1.4, that this agreement is binding on both parties. So there is no way for one party to have to be bound by this thing and then the other party to get out of it scot-free. Those are not contracts. Contracts require a bilateral contract, requires a sacrifice of rights from each party. That is how the vast majority of contracts work. Anything else is just a promise, and promises can't be enforced by the courts except under very limited circumstances. So you have a mutual exchange of promises that are binding and restrict the rights of each party. In this case, the event is restricted in their right to do something else with the space they're going to give to the voice actor or other guest, and the voice actor is restricted from going somewhere else during the time frame. They're restricted to doing what they're promised to do. It cannot be altered or changed unless agreed to in writing by the guest and or the guest agent. No oral representation, warranty, condition, or agreement of any kind or nature whatsoever shall be binding unless specifically incorporated into this agreement. So if there is some sort of extra thing that gets negotiated at a later date, who knows, anything could kind of come up and they want to incorporate that into this document. It's only binding if they actually incorporate it into the document in the same way that an appendix would be incorporated into the document. All right. Now, it's important that no oral representation, warranty, or condition be included, because when you're talking to someone at the preliminary stages of a negotiation for a contract, you may make some representations and promises that don't end up coming to fruition. Now, for whatever reason, that's not nefarious, right? You could say, well, maybe I want to pay you 25% off the ticket sales if you'll come. I could think about something like that. And then you guys agree that that's actually not necessary later on in your oral conversation. Well, then you wouldn't want to try and enforce that on someone else based on a prior conversation if it's not in this document. The idea is that I guess, a brief bit on contract law. The piece of paper that you have is not the contract. This is a written memorialization of the contract. The contract is the metaphysical agreement between two people on a set of terms and conditions. Now, we memorialize it in paper just in case something goes wrong. That's the idea. But you form contracts without a piece of paper all the time. You make agreements with other people, and then you fulfill them. Many service agreements have no written contract, no document that you would point to. You just say, well, I asked him to do this. He said it would cost this much. We both agreed, and that's how it happened. That's fine. But we reduce these to writing so that there is a memorialized agreement in case something goes wrong. So the next section that kind of matters is 2.3. This is on the monetization and compensation front. It says guests will retain 100% of all proceeds collected during the event. So this is any sort of proceeds from their signature or viewing or a meet and greet or something like that, where the guest is getting paid by someone for something. They get to keep all of that. That means that whatever the guest gets, the guest doesn't have to pay the convention anything. Now, this doesn't mean that 100% of the money that comes in that is around the guest is going to go to the guest. No, this just means that the money that comes to the guest at the convention remains with the guest and they don't pay anything back. Because we'll see a little bit below the meet and greet amount, that gets actually split between the guest and the venue. But I just wanted to point out that the guests in this contract retain 100% of the money that they make. There's no fee to the convention. Again, the convention makes residual income by having those voice actors attract other people to the convention, either through ticket sales for attendees or through vendors and merchandise people who are there, or even the ability to gather other VAs or other artists based on the popularity of the people who are showing up. Okay, so there's that. Next, we get to go down to 2.2E. This is about those meet and greets that I was talking about. Meet and greet amount to be paid out to guests will count toward the guarantee is applicable. They mean if applicable. That's a typographical error that is not a big problem at all. But basically, there's a meet and greet fee. They talk about it up here, but it's basically $50, and the guest gets 25 of that. And the venue and the photographer split the remaining 25 with some other agreement. So again, not all the money that involves the guest goes to the guest, but anything that does go to the guest stays there. That's why I highlighted that section. So the next part, 3.4, this is in the guest responsibility section. The guest agrees not to appear at another event within 50 miles of the event within 60 days before or after the event date. So this is a non-compete clause. Basically, it just means that within that 60, well, I guess technically it's a 120-day window, plus or minus a couple days for the convention. 120-day window where the guest can't be at another event within 50 miles. Now, this is so you don't have one convention spring up on Friday, for example, and then another convention piggyback off of that first convention and use the advertising and marketing that the first convention does and just says, oh, by the way, we're a short Uber ride away. You can just come on over. They don't want to do that. They put a lot of effort into marketing and promoting their convention. They can't have another event just spring up and say, by the way, we're going to have Todd Habercorn at this convention the next day. Just come see him there, like a tweet or something like that, that piggybacks on all the marketing and promotion that was done before. This is just to protect yourself for the convention, and it restricts the guests' activities for that 120-day window. And let me tell you, non-competes are, in most jurisdictions, very well respected. Very well respected by the courts. There's a public policy interest in non-competes. Everything's fine with them. There is no reason for people to get around them. The only problem is if they're too onerous on the person. Now, these are specific appearances for a very short period of time, usually 1 to 3 days. There is very little that they could do to make this too onerous on the person. A 50-mile radius is going to cover large metropolitan areas typically, and that means that, conventions tend to space out if you got multiple conventions in one metro area, they're going to be spacing this out and planning for that because they don't want people just trying to hammer through all of these things on the same weekend. It's not good for anybody's business. So that's why they have this non-compete. It's going to be enforceable. It's very reasonable to have something like this. All right, on to the section that matters for the discussion going on with Vic Mignogna, with KamehaCon, with these other people like Monica Rial canceling their appearances. This is what matters: cancellation. It is agreed that both parties are to make their best efforts in order to attend and or present at the event as scheduled. In addition, I'm not going to read through these whole things, but there is a lot here, so stick with me. Once a guest has been advertised or promoted in any way to appear at the event, neither the event nor the guest may change the parameters of this agreement or cancel the guest's appearance for any reason other than as outlined in section 4.3 and 4.4. Now that's important because once they've been advertised or promoted, not even a writing technically should change it. Now, you can always just have a mutual agreement to change the contract, but you can't you have no leverage. Neither party has any leverage in this situation because once the event promotes it, they technically can't cancel or change the parameters of the appearance on the guest. And once the event is promoted, the guest can't change the parameters or cancel on the venue outside of some limited circumstances. And those are an act of God, fire, act of government or state, criminal act of any third party, war, civil commotion, insurrection, act of terrorism, embargo, labor disputes of whatever nature, adverse weather conditions, event cancellation, and any other reason beyond the control of either party. Now, importantly, these have to be like a criminal act of a third party, for example, has to be something that would cause the guest or the event to be unable to perform. It has to be related to the activity, right? You can't just say, well, there was a drunk driver on 3rd Street, so I couldn't go. That doesn't make any sense. It would have to be a drunk driver striking their car or something like that, causing them injury, causing them significant delay. That would be the type of crime we're talking about. A mugging, a kidnapping, something that actually prevented them from performing on the contract. All right. When that happens, the party shall give written notice. And now the party could be either the guest or the event venue. Like if the event venue, if the building burns to the ground, they can't host the event, right? Obviously. So then they're not in breach of the contract to the guest unless they burned it down themselves. They're not going to have to pay out to the guest because the building burned down beyond their control. But either party, whoever is unable to perform, must give. Shall means must in contracts. Let's be very clear. It's not like a suggestion, it's a demand. Shall give written notice to the other of the inability, which sets out full details of the reasons therefore, providing substantial proof of reason. So they have to have a reason that actually proves that they cannot perform in the way that they're supposed to perform because of the qualifying act. All right. That's one section on cancellation. Here's another section. So they really don't want guests to cancel. Guests shall not be liable for failure to appear for these extra reasons. So the venue can't get a disability, illness, or death, right? The venue is just the venue. And you have staff. So even if a key staff member falls ill on that day, there's other people and the show goes on. But the guest has their own specific provisions here that are added to the other ones. Disability, illness, accident of guest or guest's immediate family member. And then, of course, it goes on to list the same things as prior. But these extra couple things, disability, illness, or accident of guest or guest family member, look, sometimes something's going to come up and it's going to make it impossible for them to appear. If they're deathly ill, if they're in a hospital, if they're vomiting, you don't want them around guests. You don't want to spread a contagion. You don't want the bad representation of having someone there. You actually don't want them to risk getting further illness or further injury say they had a bad slip and fall and injured their back or a leg or something like that, you wouldn't want to have them at the convention up on their feet for a long period of time or sitting in an uncomfortable chair, something that could aggravate or cause extra damage. So they have an exit provision for those specific things. However, it's that. However, that's it. The aforementioned provisions, the act of God, fire, and all that stuff apply. And then disability, illness, or accident. Nothing else. If you do any other excuse to not show up, you're in breach of the contract. So once notification of the guest cancellation is given to the event, they will immediately cease all advertising and promotion. Announcement of the guest cancellation must be placed in any and all of the guests and the event's websites, promoting appearance within 24 hours of that notification. Any advertising or promoting of the guest appearance will be removed from the event website within 24 hours of cancellation. Now, this is when the event gets notified. There's potentially a lag period between someone telling an event that they're going to cancel their contract, they're not going to appear, and the event, and that either the event or the guest making that public. Those are two separate events. It's supposed to happen within 24 hours, and it's incumbent on both of them. Okay. Here's the final exit clause for the guest, is that the guest may also cancel appearance if required to be in attendance for film and or television work or other professional obligations of work that may fall outside the entertainment industry. Now, when that happens, you have to, again, provide evidence that this is a true thing. And it probably can't be manufactured after the time that you're going ahead and breaching your contract or notifying the venue of cancellation. If it's not a good cause, the venue would still have an argument that this doesn't impact your ability to perform. You could have avoided this, something like that. They'd have to make that argument in court or in negotiations or whatever. The final section of this, it's not the final section. Sorry. The next to last section of this contract that I've highlighted is section 4.4. Guests may not cancel appearance at event to attend another autograph appearance unless guest is contractually obligated to a studio for an upcoming film or television appearance. So if they have a conflicting appearance that is part of the studio, for an upcoming film or television appearance, then they would be able to cancel. Other than that, they would not. And that's because some of these film and studio produced events can be, they can spring up very quickly, they can cost quite a bit, and they can have a lot of sunk costs in there. And this could be conflicting with a contract that is more important or larger or something like that. So they would have to have that good reason to cancel as well. Other than that, nada. All right. Finally, final section I have highlighted is in this miscellaneous section. Agent and guest agree that, unless otherwise provided by mutual agreement in writing, all communications by, among, or between the event, guest, and agent concerning the event, arrangements for the event, this agreement, including the appendices, and or any of the terms of this agreement are confidential and shall not be disclosed, shared, or communicated to any person or entity other than guest or agent. That means that if they were to go ahead and disclose any of those things, the contract would be breached. You can't disclose it, it would be a breach. Okay? So that's going to apply to an executed contract specifically. Now, I will point out that this contract has not been executed by both parties. There's no party information up here. Disclosure of this contract does not, or this contract form or template does not in any way nullify, void, or breach any contract on the part of this event. The fact that we're not even able to know who this contract would be for kind of goes and speaks to that. But this does not nullify or void anything. If there was another contract leaked to another reporting organization, we'll call it, and that contract was not leaked by a particular convention, but was leaked by, even if it was a particular convention, or the guest, and it had that same provision in it, then that person would be in breach of their contract. Or if they went ahead and released any texts or emails or anything like that, they would be in breach of their contract. So that's how that would go. The only person you can release that information to would be some actual representing agent who has the full authority to act on behalf of that person or the venue itself. So that's the whole part of this contract. It's actually fairly well constructed. It's effective. Here's the problem. What happens if they do cancel? Not there, right? Not in the contract. So you're left to common law remedies. Now, the common law remedy for an artist canceling would be some sort of damage caused by that artist canceling. The artist would have a damage for their minimum guarantee plus expected income that they would have to make, they would have to make an argument on what that expected income would be. Now, let's say their guarantee was $1,000, but at the past 2 years of this particular convention, they made $10,000. Well, then their expected income is probably about $10,000. They could reasonably assert that they'll make $10,000 at this convention. Now, let's say their last 2 convention appearances were only $2,000. However, this particular season, they've been making significantly more at every other convention that they've made in prior years at the same conventions. Well, then they'd make an argument that the value of their appearance has increased. Maybe there was a new movie that they were in or a new series, or they got a more prominent role. Who knows? All sorts of things like that could happen. In any case, right now it's an argument. If either party breaches, if the guest breaches, the event venue has to try and measure out how much damage that caused. Now, some damages could be presumed. Like, let's say if someone suggested that the event was not secure, that would potentially be business defamation in addition to breach. Those damages would be presumed. They wouldn't have to be proven because you wouldn't be able to show how much damage was caused by people hearing that statement. It's a reputation damage thing, and you don't always have to prove direct damages. But for the breach of contract, you probably do. Again, for the guest, it's pretty easy because they've at least got this guarantee. And they'd say, look, this is my guarantee. Here's my travel expenses. Here's my missed opportunity from going to a different convention, something like that. These would be the arguments they would make. But this is not very good contract writing when you are looking at an adversarial process. This type of contract is written with a very amicable, friendly process, right? Well, if you cancel, I guess we'll just have to figure it out because no one's going to cancel ever. We're in a different world than when this contract was written. What I would suggest is some sort of, it's a clause called a liquidated damages clause. And so the liquidated damages clause would state something along the lines of, guest and agent and venue agree that it would be impossible to measure the damage of a cancellation within X amount of days of this convention. Okay? So you're going to set up a timeline. You're going to say, once we get to a certain point, if you cancel, it may be too late for us to book. We've already sunk significant marketing costs in. You've lost opportunities to book yourself elsewhere, whatever that is. There's a sunk cost that has happened. Okay, so you say within, say, 60 days of the event, the guest, agent, and event agree that within 60 days of the event, it would be impossible to calculate the amount of damage that could be done from a cancellation without sufficient cause. Since we cannot determine an amount, we agree that the appropriate amount of damages in this instance will be X amount of dollars. That's going to be depending on the caliber of guests that you have. If you have some no-name guest, it would probably be somewhere along the lines of $1,000 to $2,000, something like that. If you're talking about a high-profile guest that's supposed to bring in fans, like for example with KamehaCon again, if you have Chris Sabat who's going to do a tour and all of that stuff, you would want a high amount of liquidated damages because you've sunk promotional cost in, advertising cost. People have bought these tickets. They're definitely going to want refunds if Chris Sabat were to pull out. that would cause a different set of problems than just someone who's coming to do a signing, right? That should be obvious. So you would set up a different liquidated damages clause for each individual person and say, look, if you pull out, you're going to have to pay the convention this much money because we made promises and representations. You've damaged our reputation. You've damaged the sales to our other contract holders. We may not be able to replace you. So here's what it's going to cost you. And it should be pricey. It should be something like $10,000 if it's a higher caliber voice actor or voice actress. You would want to look at their minimum guarantee, and you'd probably want to add some money to that. That's how I would write it. Now, as for guests, let me give you some negotiation advice. You guys are valuable. You know that because you have a minimum guarantee. But if they cancel, do you get your minimum guarantee? Do you get it? I mean, do you have to bring them to court? Do you have to pay a bunch of money to do it? So, I'll talk about, there's one more provision, that liquidated damages clause, that should definitely be in there for both parties. And we'll talk about that at the end in just a second. For the guests, you should clarify, because you always want to clarify in a contract, if you've got a term that matters, that the liquidated damages shall be the appearance fee plus X amount of dollars, right? Transfer fees on travel or any travel expenses, anything like that. You should have an X amount of dollar extra fee over your minimum guarantee. You shouldn't just be collecting that minimum guarantee and then having to make an argument about the extra. That's the beauty of this kind of clause, is you get to pad in the idea that you're going to exceed your goal. That's the whole purpose of coming there. And it makes it more painful for the convention to get rid of you. Like, well, if they come, and even if they perform nothing, but they show up and sit there, I pay them $5,000. But if I cancel them, I have to pay them 10. That doesn't make any sense. I'm going to have them come even if they suck, right? Even if no one wants to see them, I want them to come because I'm going to lose less by having them there than I will by canceling them. Or if they think that the hit is going to be so bad to the reputation of the venue or the event, then they pay. They pay. That's how it goes. And now you can have different clauses and provisions. I mean, they could make some sort of moral character for fitness or something put in there. They could say that if there's a specific criminal allegation against the guest, then the guest the cancellation is justified. They could do stuff like that. But the most important thing, in my opinion, is to lay out what the damages are if a party breaches, especially within a critical time period, because you may not be able to replace them. And even if you do replace them, if you're not refunding tickets, for example, KamehaCon, my understanding is that there are no refunds. Guests are just subject to cancellation. If that's the case, if you're not refunding tickets to people, you should know how much pain you're going to endure for that cancellation, and that should be recouped from the party who does the canceling. Okay? Here's the final provision of that liquidated damages clause, or any damages clause that they may have. It should be just a standard term in this thing. And the event venue should write it this way, and guests should negotiate it both ways. But the venue should probably write, in the event that guest cancels their obligation without sufficient cause as laid out in Section 4, in the event that guest cancels without sufficient cause, guest shall be liable to venue for all attorney's fees required to collect on amount owed. Put it in there. Put that in there. That's free contract advice. If the guest cancels on the venue, then the guest should have to pay the attorney, because otherwise the guest will just say, well, I'm not going to pay you, right? Come get me. Come sue me in another state, do all this stuff, call me into court, try and enforce the judgment. Nuh-uh. If they're going to make you hire an attorney to do all that stuff, then they should have to pay when they lose. Period. Put it in there. Do it. I don't know. I don't know how else to say it. Now, guests, I can't give you legal advice or the event venue legal advice. Obviously, you'd want to talk it over with your counsel. But the guests, when you see that clause in there, it says, if I cancel on them, I'm going to have to pay their attorney's fees to collect a fee from me. Why don't I go ahead and pencil in the event that venue cancels guests within said time period, venue will pay attorney's fees for any collection efforts made by guest. Same sort of thing. Costs and fees should be included in this damages clause. Again, cons have run in this wonderful world where basically nobody gets canceled. It's extremely rare that they get canceled for unforeseen circumstances. Now, people drop out from illnesses. People have conflicting agreements and work it out with the conventions because everybody is, again, it's mutually beneficial for everybody to participate in this. Now that we're moving, and trust me, you're moving into a more adversarial system where a venue can cancel a guest because of an allegation or because of someone not liking them or whatever, because someone puts pressure on them. The venue is canceling a guest, or a guest can just walk away and say, nah, you know what? I'm not going to come. They can announce it in advance and say, I'm not going to come. I'm going to specifically break my contract and host a competing event over here. Now you have to negotiate with me. Nope. First of all, you don't now. You don't have to negotiate with them at all. But second of all, if you put in a clause that says, nope, liquidated damages and attorney's fees for the collection, good luck. Good luck on just announcing a cancellation ahead of time and not providing sufficient proof that one of these limited exceptions applies. That's the type of stuff that should be in this contract. Again, overall, it's pretty good. It's pretty good. Now, maybe they should get more specific. We saw with Todd Haberkorn being removed from a panel at ZenkaiCon. Maybe there should be a provision where if you are not appearing at your scheduled panel, either because the guest or the venue decide to cancel without, some sort of alternative thing being set up, there could be a miniature liquidated damages because, that's a person committing to a scheduling event and then having that dropped on them. They could have some sort of provision to negotiate that. Pre-negotiate it, put it in the contract, write it down. That's the point of all this. So anyways, guys, I just really wanted to go through this contract in a more focused way, hammer on the important points, kind of explain how they work, and then talk about some things that this contract is missing. It's not missing much, really not. It's sufficient for most things, but as events like this pop up and people are walking away, completely disrespecting the terms of the contract, or the event venue is just canceling people and completely disrespecting the terms that they agreed to as well. I mean, you guys are now in an adversarial system. Welcome to it. The water is fine. Just listen to your attorneys. Go ahead and modify the contracts, live and learn from what has happened. And as you modify them, make sure you negotiate out ahead of time everything that's important to you and start slapping it in the document. You're not going to increase it as much as you think, but it is going to be very important. All right, guys, I hope you found this video educational and informative. If you did, please go ahead, like, share, subscribe if you haven't subscribed. Oh my Lord. And you can follow all of the ongoing drama and legalisms and all of that stuff with the Vic Mignogna situation by subscribing to my channel. But really, my channel is about education as well. So that's why I did this video. I hope you enjoyed it. Have a good night. Peace.